Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
Know your lane for what you saying, yo. Silly with my 9 milli with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While up in the club, every while in the studio. You don't wanna vibe, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. Like a nigga that'll slap me with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, nigga, shorty, she a little cutie, yo. The way you shake it, make me wanna get all in the booty, yo. With no lane for what you saying, yo.
Diva Divine Light.
Really my heart to me. That's what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. That's what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. That's what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. That's what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. That's what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you really my heart to me. That's what you got for me. Put more than hands with my eyes to see. Still $1 in the place to be. If you.
Here comes the pitch, and it comes in wide. Another combo.
Yo. What's up, guys? I know I said I wasn't going to do no more goddamn R. Kelly bullshit, but you know what? Everybody give me a thumbs up, please. Let me know that you can hear me loud and clear, that my microphone is not going in the matrix, and I sound loud and clear. Please, please, please. And I will do a roll call. Shout out to everybody who's here. Welcome, welcome, welcome. Welcome back, guys. You know, ay, Dios mío. And they say R. Kelly is done, right? We should be done with him. Que he's convicted already. Leave him alone. All this wah, crying and shit. I can't. So, I mean, you know what? In this sector, you know, people have your emotions going up and down, side to side, all around. People be bugging. It's crazy. I mean, I've never in my life ever heard or seen of any goddamn commotion, drama, bullshit for one man. Never. So I hope everybody had a good Friday. I hope everybody's having a good Saturday. Oh, Lord. Right now I'm about to light up my spliff. Yep. Because a bitch like me need it right now, especially since I'm about to talk about this bullshit. So, Levi. Bro. I gotta get a new mouse pad. So, let me say welcome to everybody who's here. Hey, Nanya, what's up, sister? Please make sure you drop your link in the chat. Okay, guys. Our sister Nanya has her own YouTube channel. Congratulations, mamita. Congratulations. Please follow her. She is starting off her channel by talking about Alexia Trivio. That's the young lady who gave birth in the hospital and then threw the baby in the trash. Yeah, she is uncovering stuff and covering that story. So please go make sure you check her out. All right, guys. Tyro. Okay. What's up, baby? Everybody say happy birthday to Ty. Ty's birthday was Thursday. Happy birthday, Ty. Also, Missy. Happy birthday to Missy. I saw Missy's name in the chat. Her birthday was just the same day as Ty, I think, or the day before. I forgot, but I love you. I know your birthday is around the same time. Why ain't I green? You're green over here, mommy. I see you green, baby. I see you green. I don't understand why you ain't green. Oh, are you a mod? You're a mod, so you're gonna be blue. I don't know. That's how I see you. I see Diva Time. She's green. On my chat over here, everybody's green. That's members. I don't see mods. Mods are all like, I guess, black or whatever. So, Cherie, what's up, my beautiful lady? Let me tell you, right? Girl. Good afternoon, sweetheart. Yes, please don't forget, guys, hit that like button. Thank you. Thank you. Thank you. Thank you. Diva Time. Diva Time. Daughter of the Most High. What's up, lady? Tay Weezy. What's up, baby? The champ is here. I haven't seen you in a minute, puppy. What's up? What's up, baby? Hope you're doing good. Good to see you. Good to see you. Missy, happy birthday, my love. Happy birthday, sweetheart. I love you. Happy birthday. God bless you. Yes. Miss me, Miss Mo. What's up, lady? Listen, you guys, I want to thank you guys for encouraging me, you know, because a lot of you guys have been hitting me up behind the scenes like, Diva, you know, the shit that you do, you might not think that it's not worth, you know, my voice isn't being heard, and you know, I'm feeling certain kinds of ways about things that I'm doing out here. Thank you so much for encouraging me to keep it up, and you know, and if I want to leave, it's okay to leave, and that you guys, you know, won't feel a kind of way, or you know, and you guys will support me no matter what it is that I do. And I appreciate you guys for all of that. I really, really do. So I'm here for you guys. I'm here. I'm fucking here, okay? Fuck the haters. Yes. I ain't going nowhere. I'm here. Banana. Banana. What's up, mama? Hey, baby, it's good to see you over here. I'll be seeing you on my Monopoly Go. Guys, anybody that's playing Monopoly Go, please try to follow me on Facebook so we can link up, trade cards and shit. Okay? And that's on period. Okay? All right, let's see. So much drama, and they will go on defending dude. Yeah, it's never ending. Steady grinding. What's up, puppy? What's up? Good to see you, sweetheart. Good to see you, sweetheart. I love it when I see my brothers in the building, you know, because it's over here. It's all about women, 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 women. We are the hierarchy out here. Okay? right? Or is it matriarch? I forgot which one, but y'all know what it is. Yes. So, yes, please go subscribe, guys. Subscribe to Nanya's new channel. Please do. And anybody who's a content creator, steady grinding, el otro allá, my boy over there, Tay Weezy, if you have a channel, any of y'all that have a channel, please drop your links so people can follow you, okay? Injustice, you better be good. What's up, Papi? R. Kelly is the world's greatest. The king is coming. You can feel how you feel, Papi. You can feel how you feel. That's what it is. You know what I mean? That's how you feel. You know how I feel about that. I don't care that you guys come in here and say that shit. I don't give a shit. That's your opinion. You know this. I try to be cool. Like I want my channel to be able to engage with everyone. This is a problem. I'm feeling stagnant. You understand? So I need to have everyone be able to have an opinion, just without all the drama and disrespect. You know what I mean? Like, we shouldn't be calling each other bitches, hoes, and all that shit in here. That's unnecessary stuff. It's just to talk about the case and things of this nature. Not to talk about people's personal lives. Like, what are we fighting for here? So, okay. All right. Right. We got zero tolerance. We're not playing no more, plain and simple. Fuck you. Okay? Right. So I love you too, mama. Thank you, steady grinding. Thank you, steady grinding. Right. Ain't that the truth? Thank you, Nanya. Yes, yes. This is my Facebook. If you guys want to follow me so we can play Monopoly. Okay. Thank you for subscribing to Nanya's channel, guys. Thank you. Right, Ty. Right. Right. But it's okay. He could be that way. He thinks we're delusional. It's all right. You know what I mean? So you know what? It's a tiff for tat. It's okay. I don't mind the tiff, the tiff for tat as far as debating wise, you know what I mean? But we ain't got to get personal and stuff like that. Like, that shit is just unnecessary. Totally. You know? So, there's a lot of fucking talk with Levi. He's driving me crazy, y'all. Levi, every time I see him, he's driving me fucking bananas. And I see he's driving Angie bananas. And he drives everyone bananas. Okay? He's a gaslighter. He's a filibuster. He's delusional. Yeah, no. But he's the cousin. He's the cousin. Because he calls him every day. So, it's verification that he's the cousin. Yo. Yes, daughter. They do like to go too far. That shit is crazy. That's the problem. That is the problem. They go too far. Anybody on either side that harasses, bullies, and do all that shit, they're going too far. They're going too far. But as they say, don't do unto others what you don't want done to you. period. So that's what I got to say about that. Even Levi didn't go as far as those last two, shaking my head. You're right. So now, it's this whole thing of going on and on and on about documents and this document and that document and where what was said and who said who and who did what and who was the culprit and who what and who why. So okay, where is wait a minute, didn't I save my stuff here? Oh Lord, I know it's saved. Please tell me. Okay, all right. Now, as you can see, the title of my show, let me review the pre-trial hearing. Okay, so I'm going to review it, and it's for the pre-trial hearing for the Eastern District of New York. That's for his New York case where he was convicted for 30 years that everybody is fighting about Jane Doe number 5 and how Jane Doe number 5, if she wasn't in the case, then maybe he would have at least got 10 years or maybe 15 years. Or maybe he would have gotten acquitted because the government didn't have a strong case. Their case was weak without Azriel. So this is their fight. Am I right? Let me know if I'm right. Right? That's their fight, right? Their fight is R. Kelly would never had gotten convicted if Azriel was not part of the case, right? Am I right? Hey, Jackie, what's up, mama? I do my own. I have enough job. Okay, she's talking about something else. Am I right? Right? So this is their battle. That if Azriel wasn't part of the trial, R. Kelly would have gotten acquitted because the government's case was weak without Azriel. And that the government purposely, secretly, behind the scenes, had a government employee send these emails to Tasha K so that then Tasha K could send it to the father, and then the father could tell the daughter about it, and then the daughter could flip and then testify against R. Kelly. So this is the crazy theory that's out there. Am I right or am I wrong? Put a 1 in the chat if I'm right. Please, just let me know I'm not talking to myself. Please. Please. Let me know. Am I right? This is the fight. This is the fight. Okay. Right. And then they're fighting about what was admissible, not admissible, all this crap. Right? Okay. So I am looking at the pre-trial hearing transcripts. Okay? I am officially on page 10. I believe that's the page. We're on page 10. Okay? And it's going to start off with the court. And the court is Judge Donnelly. Okay? So these are the words, and I quote, these are the words from Judge Ann Donnelly. Okay? Let me see if I can put this on the screen. Okay. I'm just going to do a solo layout. Right. Let me do it this way. The reason why it looks small, guys, is because I want to be able to look at the chat too. Let me see if maybe I can make it a little bigger this way. Maybe it'll see it. No, it's going weird. Okay, for some reason, I don't know what I just did, but okay. All right, can you guys see it? Let me know. Is it too small? Should I make it bigger? Hey, True Strong, what's up, sweetheart? She said, I've been sick of these real slow ass motherfuckers. They need to get a life. Okay, sweetheart, be careful driving. Cooking dinner and listening. Okay, sweetheart. Yeah, that's what I was supposed to be doing, cooking, but thank God the husband bought some Popeyes, so there it is. They can eat when they're ready. So, all right, I want to know, do you guys see it here? Because I'm going to read it anyway, so whatever. Like I said, I want it to be small so I can see the chat as well, because I don't have my other devices with me. Matter of fact, here is my phone. Let me see, it's my phone. My phone's on 50%. That shit about to die soon. But I got it there. But I'm not looking at it. Okay. Now, here in this part, Judge Ann Donnelly says, and I'm quoting her now, you know, let's go through them all because that's what I'm going to do anyway. And then you can tell me. The other thing I'll say about notice is that I'm the one who set the motion schedule for motions in Lemonade, and I don't. The only thing I recall about that is that the defense asked for extra time, which I granted. So that was what the schedule was. And if there was some need to have it sooner, I'm sure you would have told me. All right. So what I'm going to do is just go through these. And if I miss one, because I did get a lot of submissions, I'm sure you'll let me know. So the first one has to do with the claims related to Jane Doe number 1. And these are allegations about conduct in 1994. Hey, Cat Talk, what's up, sweetheart? God bless you. Hope you're doing good today, sweetie. The government's position is that this evidence is direct evidence of the enterprise, that it provides the motive for the charge in racketeering, for the conduct in the Racketeering Act 1, and that it is inextricably intertwined with that. And so it's clearly relevant, and it clearly shows a motive for Racketeering Act number 1. So that is admissible. So she's admitting whatever evidence for Lee at the moment. Right? Then here in this part, Ms. Becker, we're on page 11. And Ms. Blank Becker, who is R. Kelly's defense lawyer at the time, says, Judge, while I believe it states something to this effect in our motion as well, while understandable that clearly Jane Doe number 1 is a listed Jane Doe of whom we knew about, no doubt. I believe what we put in our motion and what we believe is that although certain parts of it are certainly relevant, there was a lot of statements made and requests to come in regarding the circumstances surrounding the marriage and so forth that we believe are more prejudicial than probative. So the judge says, well, let me just say this generally about all of it, right? And then Ms. Blankbecker cut her off and she says, sure. The judge says, this evidence is that, I think I've said this before. I don't have the 3500 material. I don't know what the testimony is going to be. I can say generally that this is relevant and it is related to the Racketeering Act. It provides the motive, and in that respect, it is clearly relevant. And not only does it provide the motive for Racketeering Act 1, it is also evidence of the allegations about the enterprise and the methods and means used to perpetrate the enterprise. So in that respect, it is clearly relevant. Obviously, with all of these things, I'm not going to permit hearsay. The evidence has to be in an admissible form. But the point of my rulings today is to tell you what's admissible and what is not. I don't think I have to go through chapter and verse with this group of experienced lawyers about the form in which the evidence takes. So let's just keep that in mind. And then Ms. Becca's like, okay, thank you, Judge. I agree. Thank you. So she let them know. Whatever evidence is going in about Aaliyah is going in about Aaliyah that has to prove with the enterprise and the Racketeering Act 1, which was bribery. Okay. Then we go on to page 14. Now, Ms. Geddes talks about Jane Doe number 7. Okay. And I'm pretty sure everybody remembers who Jane Doe number 7 is, right? That's our girl, Angela, a.k.a. JoJo, right? So now the judge responds to Ms. Geddes because Ms. Geddes says, Jane Doe number 7. And then the judge says, sorry, Jane Doe number 7 witnessed the contact with Jane Doe number 1. It's clearly relevant. If you're going to dispute it, you can cross-examine her about it. But if that's not something that it's directly relevant to the first Racketeering Act. Then Mr. Farinella says, and I do believe Jane Doe number 7 is one of the Jane Does that was just recently revealed. I don't recall if seeing her. And then Ms. Geddes says, that's correct. Mr. Farinella says, in the original 3500 material, so I would ask the court before making a ruling if we can at least have just a very short window of time to review. And the judge said, okay. So in other words, Jane Doe number 7's information came in the 3500 material. And that usually happened to where they said it was going to happen like 45 days. They were going to get the materials before the trial. 45 days or something like that. So 45 days later, they got the stuff. 45 days before the trials when they got it. So now Farinella says, because there are a number of new disclosures, and again, we have a limited amount of time to respond. Then Judge Donnelly says, that's fine if you want to take some time to review that and just submit a letter on that. That's perfectly fine. But I think, do you want me to give you a deadline for that? Mr. Farinella said, sure. The judge said, can you give it to me in, let's see, what's today? Tuesday? Can you give it to me by the end of the week, by Friday? Mr. Farinella said, yes, Your Honor, I can. The judge says, then can the government, I hate to ruin your weekend, but can you respond by Monday? Ms. Geddes says, yes, Judge. So the judge says, and if there's any reply that you wanted to file, you can do it the next day. Okay? Mr. Farinella said, understood, Your Honor, thank you. The judge said, sure, all right. Then Judge Donnelly continues to say, the next request has to do with Jane Doe number 8. In 1994, the government proffers Jane Doe number 8 was in a concert of the defendants and was directed to go backstage by the defendant's associates and that the defendant had sexual contact with her. As the government has proffered before, they represent that this is direct evidence of enterprise and its means and methods. So, here she's talking about how this evidence is direct evidence to the enterprise for their means and methods, because she was at a concert and she was directed to go backstage by the defendant's associates. Okay? And then the defendant had sexual contact with her. Then Judge Donnelly says, this is an example. And maybe I don't have to repeat it, but this is really not propensity evidence. This is evidence that is offered to show the existence of the enterprise and the methods undertaken to perpetrate the evidence. So it is relevant and it's not unduly prejudicial. It's no more inflammatory than the charged offenses, and so that one is admissible. Okay? Then she says, the next item refers to Jane Doe number 10 in 2001. This is similar to the somewhat similar. It's related to the previous one, but it also, I take that back. I've got it's not, this has to do with Jane Doe number 10 being recruited by an associate at a concert when Jane Doe was 16, and at some point, Jane Doe became concerned that an encounter with the defendant was filmed, and so that she reached a settlement with the defendant on that matter. Now, this is not one of those things about which you didn't know, is it, Mr. Farinella? So Mr. Farinella says, I'm reviewing. Judge Donnelly says, take your time. Mr. Farinella says, the original 3,500 material names, and I do not believe I see, Ms. Geddes says, Your Honor, excuse me, we provided evidence of this contact in Rule 16 discovery. It's not been disclosed in the 3,500. material. The judge says, I'm sorry, it was disclosed in Rule 16, pursuant to Rule 16? Ms. Geddes says, that's correct. Judge Donnelly says, okay. Ms. Geddes says, but not Rule 3500. And then the judge says, okay. Ms. Geddes says, not 3500, excuse me. Then the judge says, so the question is, I don't think there's any question that it is relevant because it, again, is evidence of the enterprise and its means and methods that the settlement, the fact that it was settled, I think, is evidence of the effort to perpetrate the existence of the enterprise. Because were that made public, it would certainly have jeopardized the existence of the enterprise. I do not believe so. It is relevant. It is not unduly prejudicial because it is, like some of this other evidence, no more inflammatory than the charged offenses, so that is admissible. Okay? So Jane Doe number 10, that's admissible. Jane Doe number 7, that's admissible. Because these are related to the means and methods of the enterprise. Okay? So this is why these girls were put in here, because they are direct evidence. Okay? Let's understand that. Please understand it. Now, Mr. CANNICK comes out and says, hey, Justice T. Thank you, Ronnie. What's up, rocking with the truth? Hi, baby. What's up, my ladies? Now, Mr. CANNICK says, Your Honor, might I, if the court is going to allow testimony or evidence that there was a settlement, then we're going to ask the court for a curative instruction at that time. The judge says, definitely. Then Mr. CANNICK says, okay. And then Judge Donnelly says, and I should have said that at the beginning, that there may be instances that I've ruled that are admissible that will require a curative instruction should the parties request it. Mr. CANNICK says, thank you, Your Honor. The judge says, okay. Jane Doe number 11 and 12. This, I think, we can put in the same category, Mr. Farinella, of those things you're going to take a look at. You see how she helped him out? Right? Mr. Farinella says, yes, Your Honor. The judge says, okay. So the next has to do with Jane Doe 13. And this relates to conduct that occurred in 2006. The evidence is that Jane Doe number 13 was 15 years old, met the defendant at a concert. This falls in the same category of relevant evidence that tends to show that the enterprise existed and is consistent with the methods and means that are contained in the indictment. It is, like the other evidence, not unduly prejudicial and no more inflammatory than the charged offenses. So that is admissible. So Jane Doe's number 11 and 12 were admissible. Okay? This is the evidence that was being submitted as admissible evidence towards the enterprise and the means and methods of how his people would bring these girls to R. Kelly backstage at a show, a concert, McDonald's, wherever it may have been, right? But in these instances, these girls all met him at concerts and stuff. So his means and methods were to what? Promote his brand, his music, as well as feeding his sexual appetite, right? His sexual misdeviance, his misconduct. Hey, Moni Mo, what's up, baby? T-Bam! What's up, my love? Right? So now, Mr. CANNICK said, wait, what was I? No. Okay, so that is admissible. Now, Judge Donnelly says, now the next category of evidence has to do with Jane Doe number 1. John Doe. Now, the next category of evidence has to do with John Doe number 1 in 2006. Now, as you can see, guys, Jane Doe number 13 was 15 in 2006. And then you have John Doe number 1, also in 2006. So he had 2 kids around him at the same time. And remember, he was still waiting for his trial. He was not supposed to be around any children at this time. He was bonded out on $750,000, but he was told to not be around any children. Remember, he was arrested in 2002 in June. They caught him in Florida and brought him home. They had to go chase his ass. Okay? He was an outlaw, like he said, running from the law because he knew they were coming for him. So he took his wife and his family and picked up and went to Florida. They found his ass in Florida. While they were in Florida, they found more porn and all that stuff. But it was a legal search and seizure. So they had to drop all those charges. He got away then. And from 2002 to 2008, he was out on bond. 2008 was his trial where he was acquitted. In the meantime, in 2006, he was hanging out with a 15-year-old and a 16 and a 17-year-old John Does. Right? Right. So, John Doe number 1 in 2006. This is Judge Donnelly speaking. Is John Doe number 1 testifying? That's my question to the government. And then Ms. Geddes says, yes, Judge. And Judge Donnelly says, what is the general, aside from the evidence you're seeking to introduce, what is the general nature of his testimony? Is he testifying about the existence of the enterprise? Ms. Geddes says, he will testify about the enterprise itself, as well as the means that the defendant used to recruit him as a minor victim, and the manner in which the defendant introduced him to other females and directed those females to engage in sexual activity with John Doe number 1 in the presence of the defendant, which is very familiar. Which is very similar to some of the forced labor allegation involving Jane Doe number 5, where the defendant engaged in a pattern of manipulation and physical abuse to ensure that Jane Doe number 5 would participate in all of the sexual activities directed by the defendant, to include sexual activity with other men and women. So the judge now says, now I just want to, this was information that was turned over in February. Ms. Geddes says, that's correct. Then Judge Donnelly says, and is that correct, Mr. Farinella, that you received that in February? Mr. Farinella says, certain aspects of that we received in February. We also received additional disclosures just recently, I believe. Ms. Geddes says, I don't think with respect to perhaps in trial prep, we have had an additional meeting with John Doe number 1, but all of the allegations that are described in the government's motion were previously disclosed in the 3500 production in February. The judge says, all right. You agree with that, Mr. Farinella? Mr. Farinella says, yes, Your Honor. So now Judge Donnelly says, okay, now the allegation is that John Doe number 1 was 17 and that the defendant promised to help him with his music aspiration and that the defendant began a sexual relationship with him. So the government's basis for admission is this is direct evidence of the enterprise and its means and methods, and it includes a common scheme, or really more a modus operandi, which is promising to help young people in the music industry in order to lure them. The evidence is certainly relevant because it demonstrates the methods that were used to perpetrate the evidence. I know that that the defense has complained that, or I'm sorry, has objected that it is more inflammatory than the charged offenses, but the charges include allegations about same-sex relationships. So it's really not more inflammatory than that. One of the allegations is that the defendant directed women, young women and girls, to engage in sex with one another. And so it's not more inflammatory than the charged offenses. And I don't recall what's in the jury questionnaire. I could look at it, but you had the information at the time, just in general, that there were allegations of same sex, that the defendant directed young women to engage in sex with other young women. You had that information, correct? And Mr. Farinella says, that information, Your Honor? The judge said, okay, I mean, this isn't really different than that. Mr. Farinella says, well, the judge says, what we can do is pose additional questions to the prospective jurors about this particular. I mean, just about those allegations in general, you know, appropriately phrased questions if that's your concern. Okay. Now we're going to go into other stuff. Let me see. Boom, boom, boom. Now on page 26, the judge says, well, I think for our purposes here today, the employee can certainly testify about her own interactions with the defendant. But I don't understand you to be asking to admit evidence of Jane Doe number 15's statements to employee number 1, correct? Ms. Geddes says that's correct. Judge said, all right. Mr. Farinella said, Your Honor, also just to ensure for the record, we have not been given any specific information as to the various employees and witnesses that have been identified in terms of specific references as to who they are. So at this point, he's saying that they didn't know who they were, who these employees were. So Judge Donnelly's like, have you given the names of the employee hold on. Have you given the names of who employee number 1 is? And Ms. Geddes responds and says, we have provided 3,500 material for each of these employees, which include their first and last names. I am happy to provide to defense counsel a list of precisely in this motion who employee 1 refers to, but the substance has been disclosed and review of that substance would readily make clear who employee number 1 is. The judge says, it might not be a bad idea just given the volume of the information that defense has to deal with. I'd like you to give them a list of, I assume they know most of them, but give them a list of the names of the people and pseudonyms that applies to them. Ms. Geddes says, we will, Judge. And the judge says, all right, let's get that done by today, okay? Ms. Geddes says, yes. The judge said, anything else that you want to say about that, Mr. Farinella? And Mr. Farinella says, no, Your Honor. The judge says, and if it's not clear, that is admissible and relevant evidence. Okay? So John Doe was admissible evidence as well. The next one has to do with Jane Doe number 16. And this spans a period of time. Do I have this correct? 2006 to 2017? And Ms. Geddes says, that's correct. So the judge says, the evidence according to the government is that Mr. Kelly began a sexual relationship with Jane Doe number 16 when she was either 16 or 17, and that she stayed with him until 2017. Apparently, I think the application is that she would be permitted to testify about the rules that Mr. Kelly enforced and what happened if there was a violation of the rules, and that she also was required to write letters that included embarrassing and false statements about herself. There's also an allegation that Mr. Kelly directed her to have sex with John Doe number 2, which was filmed. All right. Let me just make sure that this is not something that's news to you. Is it, Mr. Farinella? Mr. Farinella says, no. The judge says, so this, again, is direct evidence of the enterprise's means and methods, and particularly over that long period of time. So it's surely relevant. It's surely admissible for that purpose as direct evidence. Assuming that Jane Doe number 16 testifies, as the government represents, it's also evidence of the control that was exercised over the various, whether they're victims or associates of the enterprise, and the ways in which control was maintained. It's not more inflammatory than the charged offenses, and so that is admissible. Then Ms. Geddes says, Your Honor, just to be clear, even if Jane Doe 16 does not testify, Jane Doe number 5 witnessed some of the physical abuse and other psychological manipulation by the defendant as to Jane Doe number 16 and Jane Doe number 17. And that is relevant to her understanding of what would happen if she violated his rules. So it is also goes to the forced labor allegation with respect to her. So Jane Doe number 16 is Dominique Skylife. Dominique was ready to testify for the government, you asshole. You stupid ass. Shut the fuck up. You don't know shit. How about that? The judge says, so your anticipation is Jane Doe number 16 will not testify? Ms. Geddes says, I'm not saying that. I'm saying even if she does not testify, I think it is still relevant and admissible because Jane Doe number 5 firsthand saw and heard what was going on, and it was relevant to it. It was one the ways in which the defendant maintained control over Jane Doe number 5 was showing her what would happen to her if she violated a rule in the same way that she had seen Jane Doe number 16 or Jane Doe number 17, which is Joy, violate a rule. The court, which is the judge, now says, well, I'm making this ruling with the same obvious proviso that the evidence has to be in admissible form. Ms. Geddes says yes. The judge says, so that would be non-hearsay, direct evidence, but the evidence itself is admissible. And to Jane Doe number 17, that is also the same pattern. And I take it you make the same arguments with regard to that. Ms. Geddes says, yes, Judge. And then the judge says, I take it also, Mr. Farinella, that this is not something that you've just learned about, correct? And Mr. Farinella says, no, Your Honor. The judge says, it's not correct, or is it correct? Mr. Farinella says, it is correct, Your Honor. The judge said, okay, this is admissible for the same reason. Let me just say, just generally, although I think this evidence is relevant and admissible as direct evidence of means and methods, there is an alternative basis for admission under Rule 413, which permits evidence of a defendant's prior sexual conduct for whatever purpose relevant. So that statute, though, the Second Circuit has made it clear that the 403 rules apply in evaluating it. And I don't think there's any question that he's charged with sex crimes. You're not disputing that, are you, Mr. Farinella, that the rule applies, the Rule 413? The question is just how the court balances it. And then Mr. Farinella says, I think the court answered its question. He's charged with sex crimes, Your Honor. Okay. So Mr. Farinella admits He's being charged with sex crimes. So yeah, these girls, yeah, you're right. According to the rule 413, yeah, we got to let all that shit in. Yep, you're right. So then Judge Donnelly's like, I just wanted to make sure there wasn't a dispute about that because I don't know that you addressed it in your letter. I mean, it is different. It's a rule that's sort of an anti-propensity rule, but it does not require the court to engage in a balancing process. But it is an alternative basis for admission. So my determination on the ones that I've ruled admissible so far have to do with the direct evidence of the enterprise. Okay, then they talk about Jane Doe number 18. I'm sorry, Jane Doe number 17. Let me make a correction. Yeah, Jane Doe number 17 was Juice. Jane Doe number 18 here I think is that girl I believe it was the girl, I think it's that girl V, I think. Not sure. Don't quote me on that, guys. But let's just continue. So Jane Doe number 18, is she testifying? And Ms. Geddes said yes. Jane Doe number 18, this is from 2016 to 2017. So the proffer is that she was recruited by one of the defendant's associates at a concert, and that she will also testify about the various rules and the consequences of violating the rules, which include various forms of physical abuse. Okay? And the allegation, and also that she was required to, like one of the other Jane Does, to write letters that contained embarrassing and false statements about herself, and that she was required to have sex with others, including Jane Doe number 5 and John Doe number 2. And that those encounters were recorded. This falls under the same category of means and methods, and it relates for that reason. It also demonstrates at least the control that the defendant exercised over victims as alleged in the indictment. It's not more inflammatory than the charged offenses, and it's also intertwined as the other evidence. The other Jane Does who will testify similarly, it is intertwined with Jane Doe number 5's testimony as I understand it. So, all right. The next has to do with the conduct in 2018 and 19 regarding Jane Doe number 6, that the defendant and his associates used threatening tactics in order to get Jane Doe number 6 to stop speaking publicly about Mr. Kelly and to drop a lawsuit. Okay? So that's talking about faith, right? Let me get something. Let me grab something to drink. Give me a second, guys. Hey, Diva, for show 2. Welcome, welcome, lady. Welcome. Welcome, Diva, for show. Welcome. I hope you enjoy the commentary. We're talking about R. Kelly and his Eastern District of New York case. We're talking about the pretrial hearing that went on and what type of evidence was admissible at his trial, and how all of this ties to the means and methods of his enterprise, as well as certain racketeering acts when it comes to forced labor, bribery, and sexual exploitation, as well as sexual exploitation, forced labor, bribery. I feel like I'm forgetting something. Help me out, guys. So now, Ms. Geddes, we're on page 33. And Ms. Geddes says that it's through John Doe number 1 and Your Honor, the government's interest in introducing this evidence is much more directed at the fact of the 2002 case and the duration in which it went. In addition, the government anticipates that part of John Doe number 1's direct examination, because it does constitute impeachment material, we would also elicit the allegation of the fact that he admits that in the 2008 he had access to a juror, and the defendant's response to that. The thing we are far more interested in introducing the fact of the 2002 charge, and that the defendant was on trial for, right? Was under indictment for such a long period of time and was untimely acquitted in 2008. So the judge says, what's the relevance of that? I'm not inclined to permit it, by the way. Just it seems he was acquitted of something for whatever reason, and it doesn't seem relevant to the enterprise. Instead, it seems to me that it's directed to showing that he's sort of been under suspicion for a long time. And I don't see an admissible purpose for that. I mean, generally, you know, the fact that somebody was acquitted of a crime, you would not be permitted to inquire into that. And I don't really see a good reason to permit it here. Obviously, if something comes out during the trial that, again, doors can be opened all the time. But I don't think that that's admissible. So I'm not going to permit that, okay? So she wasn't permitting any of the evidence as far as talking about how John Doe number 1 in R. Kelly's 2002 case, he wound up reaching out to a juror to flip the juror to say R. Kelly's not guilty. This is one of the reasons why, another one of the reasons why R. Kelly had an anonymous juror, an anonymous jury. Thank you, Moni Mo. Okay. This is why his jurors were anonymous, because John Doe number 1 testified to the grand jury that he reached out to one of those jurors in 2002 to convince the man to say that R. Kelly wasn't guilty. Now, I wish to God they would have had John Doe number 1 at the Chicago trial, because that could have been a good example of conspiracy to conspire to have this man acquitted by paying people off. And I honestly think, in my own opinion, I think the judge was paid off. I think the judge was paid off to have certain evidence as inadmissible. And also certain people not to testify and certain evidence to go in. That trial was a shamble, I tell you that. It really was. He should have done that time a long time ago. He wouldn't be here today. if he would have done what he had to do back then. But he had people in his pockets, I'm telling you. So now the judge says the next has to do with an effort in 2019 to obtain child pornography. Is this charged anywhere? I think that's too, Moni Mo. Word up. You know what? In Chicago, that trial, they could have established the conspiracy a little bit better, I think, if Jack Palladino was still alive, if Linda Mensch was still alive, if the father, Gregory Landfair, was still alive, and who was the other one that was missing? There was 3 or 4 people that are deceased that were supposed to be at that trial. I can't think of the other person, darn it. Now, Ms. Geddes says, no, Your Honor. And then the judge said, I'm not permitting that either. It's not clearly relevant, although it has some relevance, but it is surely unduly prejudicial. And I would also note, at least as far as I can tell, the recordings, to the extent they exist, it's not even been confirmed that they are child pornography. So that's unduly prejudicial, and I'm not going to permit that. The next category of evidence has to do with audio recordings that depict the defendant yelling and physically assaulting women, and those are clearly admissible as direct evidence of the methods used to perpetrate the enterprise, and it is direct evidence of the defendant participating in it. It's not more inflammatory than the charged offenses. In fact, it is evidence of the charged offenses, and so that is admissible. So here they admitted the audios of R. Kelly assaulting women, which was Lisa Van Allen, and there was another girl there with her. I don't even know. I'm not sure if it was RL or someone else. So that's where Judge Donnelly admitted the evidence of the audio of Lisa Van Allen being yelled at and getting beaten up. Now, the next category of evidence, I want to make a general observation about these applications to put in witnesses' text messages. Here we go about infamous text messages, okay? Text messages, all right? Let's see what they say about text messages, okay? The next category of evidence, I want to make a general observation about these applications to put in witnesses' text messages. They may become relevant if the witness is challenged with is accused of a prior inconsistent statement. Sorry, I need a little something to drink. Oh, that's one of your people, baby. Thank you for coming, Diva, for show. Yeah, I think a lot of people were paid off too, girl. There's just not enough evidence of that because you know what? R. Kelly likes to pay and do a lot with cash. Excuse me, guys. I gotta get another bottle of water. Okay, so now we're talking about witness text messages. She says they may become relevant if the witness is challenged with or is accused, she says, is accused of a prior inconsistent statement. Some of them seem to fall under that ancient Hillman case from the Supreme Court from, well, let's say from a long time ago, that seem to talk about her declarations of future intent. That she's going to a concert, that she's going to go to Chicago, that she's staying in a particular hotel. Those are sort of classic declarations of future intent that are admissible. They are non-hearsay. Okay. Again, I'm going to go to the beginning of this paragraph, okay? All right? So that everyone can understand why Judge Donnelly let in those text messages. The text messages that were discussed at trial, right? They did refer to quite a few text messages, okay? Now, she's going to say why a lot of those text messages are going to be admissible and why they are allowed to be entered, okay? So I'm going to read that again, all right? The next category of evidence, I want to make a general observation about these applications to put in witnesses' text messages. They may become relevant if the witness is challenged with is accused of a prior inconsistent statement. So that means if they say, okay, so you said that on the night of Thursday, the 23rd, you said you went with R. Kelly where? Well, we went with him to Chicago. Okay, well, in this text message, it says that you went with him to Chicago on Friday, the 23rd. So what you talking about? Can you recall that? Is that your recollection? Can you, right? So that's what she means by that, right? That they can use the text messages for those kind of purposes, right? Okay. Inconsistent statements, correct? Right. Tasha! Right? So now, and she says that that's not hearsay, okay? Now, she also says that some of them seem to fall under that ancient Hillman case from the Supreme Court from, well, let's say from a long time ago, that seemed to talk about her declaration of future intent. So that she's going to a concert, right? So these are the examples. So the text messages should show that she's going to a concert, and that she's going to go to Chicago, and that she's staying in a particular hotel. And those are the sort of classic declarations of future intent that are admissible. They are non-hearsay. It's direct evidence. Okay? So the text recounting things that happened, on the other hand, and things that she did are not declarations of future intent. The text recounting things that happened, on the other hand, and things that she did, are not declarations of future intent. Did you understand that, Levi? Okay. So they don't seem to me to be, they are not excited utterances. They are not present sense impressions. So those are not admissible unless she's challenged about, or if she has a failure of memory, and they are still not admissible. But she can surely have her recollection refreshed with them, or if she's challenged that she's making the whole thing up, they may come in that regard. So I think this is all to say that this is premature. So I think we will wait to see what happens. So again, Levi, the text messages recounting things that happened, on the other hand, and things that she did are not declarations of future intent. Okay? They are not excited utterances. They are not present sense impressions. So those are not admissible unless she's challenged about, or if she has a failure of memory. So being that they weren't able to bring up the parents at the trial like that, those text messages were inadmissible. Now, can you understand why those other text messages weren't part of this trial? The only thing that they wanted to see, as far as any text messages, had to be that she was going to Chicago, that she was staying at a particular hotel, that she was going to a concert, and things of this nature. Okay? Now, she says the same thing can be said about these employees' messages. So the same thing goes to the text messages between the employees about the Jane Does. It more or less has to be relative to the charge. It has to be relative to the charges. It has to be relative to the charges. So they don't want to know all the other hoopla that came in the middle of those text messages. They just want certain points of certain parts of certain text messages. All that other shit is irrelevant, moot, meritless, womp womp. Okay? Right. So now, Ms. Geddes says yes. And then the judge says, they may be, if the witnesses are challenged, that this is a recent fabrication that they may very well be admissible in that regard. And so the employees' text messages, again, we'll have to see what happens at the trial. There are text messages from Mr. Kelly, which are, I believe, there are. Is that correct, Ms. Geddes? Ms. Geddes says, yes, Your Honor. I'm sorry. And then the judge says, okay. So now we know there's text messages in these governments, the GX233. We don't know what letter it is. It could be Z, F, A. And well, actually, we know what A is. It could be letter C, letter D. I don't know. Okay? Don't worry, guys. God willing, in due time. That's all I have to say, okay? Now, the judge said again, they may be, if the witnesses are challenged, that there is a recent fabrication that may very well be admissible in that regard. And so the employees' text messages, again, we'll have to see what happens at the trial. There are text messages from Mr. Kelly, which are, I believe there are. Is that correct, Ms. Geddes? Ms. Geddes says, yes, Your Honor. Then the judge says, okay, you're not challenging those. Are you, Mr. Farinella? Mr. Kelly's text messages of a party opponent. Mr. Farinella says, I mean, to the extent they've been established as his text messages, they speak for themselves, Your Honor. The judge says, okay, I'm just making sure. I mean, is that going to be a challenge? One thing, just sort of as a general matter, if you can resolve things without the need to call phone company representatives, if you're challenging whether they really are his messages, by all means, go ahead. But as exciting it is to hear a witness testify about from the phone company, I think we can. Our lives will be complete if we don't have that. So if you can work out those kinds of things, I think it's better for everybody. All right. So that's really what I have to say about all those text messages. That it is just early to say. I'd like the next category of evidence has to do with what's been termed an electronic note that Jane Doe number 5 wrote in 2018 that appears to be a list of rules. I'm just going to ask the government to remind me of what the circumstances under which that note was created. And Ms. Geddes says, the government executed a search warrant at the defendant's residence, and there a cell phone was found that had been used by Jane Doe number 5. And on that cell phone was that electronic note in like the notes section on an iPhone. So the judge says, is it your position that was in the nature of a reminder to herself about what the rules were? Ms. Geddes says, based on statements made by the defendant. Oh, the judge says, okay, so now I'm not sure I understand. So there's a search warrant that's conducted at the defendant's apartment, correct so far? Ms. Geddes says, yes. The judge says, there is a cell phone that was used by Jane Doe number 5 also, correct? Ms. Geddes says, yes, Judge. The judge says, and in the cell phone, it's not a text message to anybody. It's in the notes section where she has a list of rules, correct? Ms. Geddes says, yes. And the judge says, does it have a title? Ms. Geddes says, no. The judge said, okay. And the government's position is that this is something that she was told that she made notes about? Ms. Getty says, that's correct. The judge says, presumably, she would testify to this as well. Ms. Getty says, yes, she will. And the judge says, so with that context, what is your position on it? Mr. Farinella says, well, given the way notes are created, it's unknown if she actually created the notes. It's on her phone, obviously. The judge says, I guess you could ask her. I mean, if she testifies, I made this list. It's being offered to prove that the list was made not for the truth of the matter asserted. So do I have that right? And Ms. Getty says, yes. The judge says, so I don't see it as hearsay. I mean, obviously, if she didn't write it, then that's the end of the inquiry. But if she says she wrote it and what the reason was, it's not hearsay. It's evidence of the fact that it was made. So with that understanding, that's admissible. So the phone that was used that R. Kelly gave her was admissible evidence. So they're using all of those notes, whatever she made in the notes section of the phone, those things are admissible. So the next thing I feel like you all can agree on this, the question about the dates of various concerts in 1994. Can't you come to some kind of stipulation about that? I know that is the question about the newspaper reporting that the concerts took place on particular dates and particular locations. I don't see that as especially controversial. Do you have any problem with that, Mr. Cannick? Mr. Cannick's like, Your Honor, there is a list. There is an archive of Mr. Kelly's concert dates. So I think we can go over those with the government and make sure that we're in agreement with actually what's listed on the archives. The judge says, I think that makes sense. See if you can do that. And then you can probably just stipulate rather than put it in those old newspaper articles. But okay. That I think covers what the government was requesting in terms of these other acts, right? Mr. Cannick says, Your Honor, may we have 1 second because there is a ruling by the court that we might want to revisit. And the judge says, I didn't hear what you said. So now, Mr. Cannick says, thank you. The court made a ruling earlier as it relates to Jane Doe number 18. What we're going to do is ask the court ruled that it was not going to allow that testimony to be elicited because it might be cumulative. We're going to ask the court to reverse on that until Mr. Farinella gets his response into the court and the government on Friday. The judge says, just remind me. I'm sorry, I'm going to look at my notes because I know this will shock you, but I don't have these committed to memory in terms of who's who. Jane number 18, Jane Doe number 18. Mr. Cannick said, right. The judge says, you want me to reserve? This had to do with the threats on the Facebook and correct. Mr. Cannick said, no. Ms. Getty says, are you referring to Jane Doe number 19? The judge said, oh, I'm looking at, sorry, what did I say? Mr. Cannick said, may I? Ms. Becker says, I'm sorry, which Jane Doe are we speaking about? The judge said 19. Ms. Becker said 19. Thank you. The judge said, okay, so 2018. This is the one that I precluded inquiry. Mr. CANNICK said 19, Jane Doe 19. The judge said, just so that I make sure I have the right thing. This is the former girlfriend that the allegation is that Mr. Kelly wanted her to decide whose team she was on and something about her family. Beautiful family that she didn't want to be handled. Mr. CANNICK said, I don't think that's the one. Ms. Geddes says, that's it. That's the one. Mr. CANNICK said, that's the one. Mr. Geddes says, that's one you just cited. Mr. CANNICK said, yes, we have to study our notes, Your Honor. The judge said, okay, you let me know about that. Mr. CANNICK said, okay. Ms. Geddes said, Your Honor, could I raise one other thing with respect to the 2002 trial? The judge says, yes. Ms. Geddes says, Jane Doe number 4's testimony is Jane Doe number 4 will testify that she first encountered the defendant when she attended his trial as a quote unquote super fan. The judge said, why don't we do with that evidence what we do in other contexts? You can refer to it as a proceeding. Ms. Geddes says, okay. And the judge said, just so it's sanitized. I think that's the way these things are generally handled. I mean, and then Ms. Geddes says, okay. The judge said, I'm saying there may be something about that proceeding that becomes relevant. But right now, let's just preclude all reference to it as a trial. All right? So the next thing I just want to cover, which should not take quite as long, has to do with the government's motion in limine regarding evidence under Rule 412. And that rule provides that evidence offered to prove that a victim engaged in other sexual behavior or offered to prove a victim's sexual predisposition is not admissible in a proceeding involving alleged sexual misconduct. There are exceptions to that, and they include whether it's offered to prove that someone other than the defendant was the source of forensic evidence or other physical evidence. The second exception has to do with sexual conduct that is offered to prove consent. And the third is more general exception, which is evidence whose exclusion would violate the defendant's constitutional rights. So a defendant who wants to offer evidence pursuant to these exceptions must file a motion that specifically describes the evidence and the purpose for which it is offered at least 14 days before trial. And there's also a provision that the victim or, if appropriate, the victim's guardian or representative be notified. So it's possible that the defense and the government are in agreement about one aspect of this, which is I think the government is intending to offer evidence that the defendant directed various Jane Doe witnesses to have sex with one another. I mean, I haven't received the motion that specifically describes the evidence that you're intending to elicit, but I don't immediately see, other than that category of evidence that I just discussed, how this could possibly be relevant. So I think the representation, and you'll certainly correct me if I'm wrong, is that you don't know what you might ask about it at this time. But that's really not sufficient under the statute. So if there's a specific, as I say, I think during the period of the charged offenses, the government will in fact elicit evidence of sexual encounters with other people and with the defendant. But I don't. What you're suggesting in the letter seems to fall squarely within the Prohibition of Rule 412. And if there's something specific that falls under those exceptions, you can surely file a letter by Friday also. But for now, I'm not going to permit that. I also think the government and defense probably agree on this religious belief question. The government doesn't want the evidence to come out, and neither does the defense. So you agree, so that involves that. They were talking about too about remember when Demetrius Smith was talking about how R. Kelly was speaking in tongues in the bathroom and all of that? Yeah, that's not admitted. Now on page 45. Let me get some more water, guys. Give me a second.
Mom, are you done? Almost. It's been 2 hours. Can you hear me? Can you hear me? No, why didn't you say anything about it? I didn't mean that. I'm the I was fast as you can.
Okay, sorry about that, guys. So now we're on page 45, and the judge says, so maybe you don't have to talk about it. It seems not helpful to anybody. So if you change your mind about that, you can let me know. Then there is a motion to preclude introducing sort of general evidence about mental health. You know, a witness's psychological history might be admissible if it goes to credibility. But just because somebody seeks counseling or help for a psychological issue does not make that person incredible. There is nothing in the submissions that I have that indicate that any of the witnesses are suffering from some mental disease that renders them unable to remember, or there is no evidence that the people are under the influence of some delusion. I also just think that as a general matter, lots of people seek psychological counseling, and that may be also true of your jurors. And I don't think you can just assume that somebody is not being credible just because they had at a time needed some help. So I'm not going to permit any inquiry into that. With respect to one of the witnesses, I think it would be decidedly unhelpful to the defense, just as a particular matter given the nature of that evidence. So unless there's showing that a witness mental health affects the witness's ability to perceive and recall, that evidence is inadmissible. The next category of evidence, I don't think you all are too far apart on this one either. This has to do with evidence about the victim's parents and the allegations that they may have participated in the scheme to extort the defendant. I don't understand that any of the parents, I don't understand that any of the parents are testifying. Is that correct? Ms. Geddes says, that's correct. The judge says, so it's certainly appropriate if you know, with a good faith basis to question the witnesses, whether the witnesses participated in such a scheme. That's certainly appropriate, but sort of a general question about what their parents did is really not. I mean, there is no direct evidence of it. So I don't know how the witness would know about it unless the witness participated in it. Then you can certainly cross-examine them about it. But just a general question about what the parents were doing, you know, in a case with allegations like this one, and the parents couldn't consent to the behavior that's alleged. So it really doesn't have any relevance. So that's not going to be admissible, just generally about the parents. But if the allegation, which is what I understand it to be, is that the particular Jane Doe witnesses were part of this plan, you can certainly ask them about that. Like I say, I don't think you're that far apart on this, so I think I've got that right. And then Mr. Farinella says, Your Honor, I would ask that we be, Ms. Blank Becker says, Judge, Mr. Farinella says, able to flesh that out. And because I do think the judge says, I'm sorry, in what form would it take? That's my question. They're not testifying. Mr. Farinella says, well, in terms of offering a defense, Your Honor, depending upon the witness's testimony, what's elicited from the witness, and what the witness says, it could be very relevant to the defense. And if in fact the defense should have available to them the possibility of calling one or either of the parents, if in fact there is information that's testified to that goes to the actual defense. I mean, the parents. Judge Donnelly says, I can't imagine what the parents could testify to that is relevant to Mr. Kelly's defense. So, on principle, no. I'm not objecting, but I think they would need to make an offer as to how it is relevant to the charges. That was Ms. Geddes who said that. Ms. Geddes said, I can't imagine what the parents could testify to that is relevant to Mr. Kelly's defense. So on principle, no, I'm not objecting, but I think they would need to make an offer as to how it is relevant to the charges. So then Judge Donnelly says, well, I think they did make an offer that, and you'll correct me if I'm wrong, the offer is that this is all an orchestration by the Jane Does and their parents to frame Mr. Kelly and to get money out of him. Do I have that about right? Ms. Becker says, yes, Judge. Mr. Farinella says, that's what the motion argues, Your Honor. Ms. Donnelly says, well, I mean, Mr. Farinella says, or that's what the motion, yes, that was. Ms. Donnelly says, perhaps you'll get a witness that will come and admit that in court. I don't know. But if there is a witness to be had and can give relevant, I mean, it's like anything else, you'll make an offer of proof. I'm not precluding you from doing that. I am precluding you from, I think it would have to be hearsay evidence. Like I say, I don't think you're that far apart. You'll be able to cross-examine the witnesses on this topic. So, with obviously appropriate questions, we just have two left. The next one is the evidence of prior good conduct. All right. So, you see what she was saying here about the parents? If R. Kelly, she said that perhaps if R. Kelly's defense team can get a witness that will come and admit that in court, she'll give them that. She said, I don't know, but if there is a witness to be had and can give relevant, and she says, and I mean relevant, it's like anything else, you'll make an offer of proof. So, before, in other words, she's saying, before you even try to say anything about the parents trying to extort R. Kelly, and if you're going to have somebody come into court to testify about that, or there's any other type of proof, then I'll let it in, as long as there is proof. So if there is proof that there was some type of exchange between the parents and R. Kelly for R. Kelly buying the daughter and the parents selling the daughter, or any type of extortion to where they threatened R. Kelly and said, listen, if you don't make this song with my daughter, I'm going to kill you. Or you better give me $350,000 because you have my daughter. Anything like that. Any type of exchange. If there's a witness that can testify to that theory or some type of paper trail evidence, a text message, a check, somebody to come and testify and say, yeah, I did do that, it's irrelevant. And it would only be hearsay evidence if it came from somebody I heard that it was said that the parent did this and did that. No, it has to be that I was there and he told me that he gave money to him or she gave money to her or whatever the exchange is. It has to be direct evidence. It can't be no hearsay shit. Viva. Okay? Please understand this. So, then she continues to say, we just have 2 left. The next one is the evidence of prior good conduct. I think part of this is going to be, I'm not 100% sure how the defense would propose this would come in. Obviously, if Mr. Kelly testifies, he can talk about his background and things like that. But to the extent that it is character evidence, it would have to come in. So she's talking about if R. Kelly decides to testify at trial. Right? Okay, let's see here. Okay, so now here, the judge is talking about using pseudonyms and stuff like that. So she says that using only their first names, and the objection is only to Jane Doe number 5. That's based on the fact that apparently some of these witnesses, I'll tell you, I haven't seen any of these. So apparently some of these witnesses have spoken in other forums. I'm not sure that's a reason to force them to testify about these particular things using their full names. So I'm going to permit the government to do that. And then she says, I know there is a concern that the jury might attribute this to the defendant. I'm going to give the jurors an instruction as it relates to the anonymous jury. So remember, he had an anonymous jury. Nobody was allowed to know who the jurors were. Not the public, not the fucking journalists, not the lawyers, not R. Kelly, not anyone. Okay? And that is the reasons why they had an anonymous jury is because in 2006, John Doe number 1, Mr. Lewis, wound up convincing one of the jurors to say R. Kelly is not guilty. He reached out to him, paid him off. Okay? All right, and I think that, yep, that is about that. Now, this happened, this trial, pre-trial hearing, I'm sorry. This pre-trial hearing happened on August 3rd, 2021, which was 2 weeks before his trial actually started. Hey, Shorty Rara, what's up, baby? So that's what I wanted to read and get it out there and let you guys know. Reread this again just so that people can understand the admissible evidence and the inadmissible evidence that was discussed at the pretrial. Okay? She talked about the text messages. She talked about the parents. She talked about the John Does. She talked about the racketeering. She talked about the means and the methods and all those things and evidence, hearsay and all that and all the rules and everything that had to go together before the trial started. Okay? So, yeah. She said intimidated much. Levi, I hope you're listening with a little bit of understanding, okay? Back to the bushes. Yes, ma'am. She said most of the time, Moni Mo said, most of the time, that's how it's done. No paper trail. Right. Right. That was them secret meetings in the judge's office before trial. Exactly, in 2008. Remember that they were talking about that in Chicago trial, that how he had all these secret damn meetings, these sidebars and side hearings without the witnesses, the prosecutors knowing what was going on. Same thing with Jeffrey Epstein. They did that same bullshit with Jeffrey Epstein. Thank you, Moni. Thank you, Mama. Thank you, baby. I'm glad you enjoy it as well, sweetheart. You know, so that's what I came here to do, guys, to come back and just give you a quick rundown. You know, I didn't read the whole thing all the way through, but I did what I did. All right, guys. So later on tonight, I set up a live for about 10 p.m. Okay. And we're going to go through the trial transcripts, page by page. I've made notes on certain pages. Okay. So that's what we're going to do later. So, guys, if you want to come back later, you can come back later. If not, I'll probably change the schedule depending on what goes on in my life, because sometimes things pop up. So depending on what happens, I might come back tonight at 10 p.m. like I set it up for. If not, I'll set it up for tomorrow. Okay, and I'll set it up for the afternoon. And we'll start from the afternoon and I'll read all the way through. All right, guys. You're very welcome, my love. Shorty, it's all right being late. Don't worry about that, mommy. You could catch up on the replay. And guys, please, let me remind you, for those who are watching my replay, when you watch the replay and if you want to contribute to the channel as a super chat and you don't want to hit my Cash App, you can always just hit the super thanks. There's a heart with a $sign inside the middle of it. And that's the super thanks. And it's like hitting up the super chat. Okay, so don't forget that little button is there, guys. For those who are on the replay, and if you like my content and you want to support the channel, you can hit that little super thanks, okay? If not, you guys know my my Cash App is $ Diva Divine Light. Let me I'm putting it up here. Okay, you could even PayPal me. All right, it's the same. It's also Diva Divine Light. And If you guys have any tips or anything that you want me to maybe look at and maybe talk about, please let me know. You can email me. My email's on the screen. All right. If you guys want to call, leave a message, because you saw my commentary. And thank you for the Cash App, baby. And if you want to call in and leave a message, you could send a text message to me. Or if you want to just call me, you can call me and talk to me. I'm here for you guys. If I can, I get back to people when I can. Y'all already know how your girl Diva works. So, guys, make sure you leave comments, okay? Leave the comments below in the comment section. Make sure it's respectful. They won't get deleted, okay? And let me know what you guys think about this pretrial hearing that I reread again for like the third time. Lord have mercy. Jesus Christ. It's bananas, right, guys? We're doing this all over again. Just so some people can get it. I don't get it. I'm confused. So, in the meantime, guys, and let me wait, espérate. And this is for my R. Kelly supporters. And your girl, don't forget, guys, leave your comments in the comment section below. Don't forget to hit that like button on your way out. And your girl Diva Divine Light is out. Peace.
You are watching Diva Divine Light.
You can fuck with me if these is red bottoms, these is bloody shoes. Hit the scoop, I can get them both. I don't want to choose, and I'm quick. Cut every nigga off, so don't get comfortable. Look, I don't dance now, I make money move. Now I gotta dance, I make money move. If I see you now, that means I don't fuck with you. I'm a boss, you a worker, bitch. I make bloody move. Now she say, gon' do what a hoop. Let's find out and see. Cardi B, you know where I'm at, you know where I be. Just a party, I'm there, I get